Yesterday, a judge in Florida made a ruling on Popcorn Planet's motion to quash Blake Lively's subpoena. Andy, who runs Popcorn Planet, and I were two of 107 content creators subpoenaed by Blake Lively for the purposes of what I highly believe to be chilling free speech. It targeted random internet users who spoke negatively of Blake Lively, even those accounts with single or double-digit subscribers, and it seemed to lean mostly towards A, female content creators, and B, people she probably didn't think would have the funds to defend themselves, with the exception of very few. There were a handful of people who were subpoenaed individually, and Andy was one of them. Most of us were subpoenaed through YouTube, TikTok, Twitter, or X, whatever you want to call it, and they were seeking highly personal and private information from our accounts. Then there was Andy, Megyn Kelly, Candace Owens, and Perez Hilton, who were subpoenaed for different information directly. Andy, I believe, was the only person who was subpoenaed both individually, directly, and through the social media subpoenas. Now, Blake has it out for Andy, obviously, because he filmed a documentary, which hasn't been released yet now in light of the subpoena, that included some crew from the film who were possibly going to say things that she didn't want to get out. It also included several content creators who gave opinions. Elsie and I were both at Andy's house to film for it a few months ago. Blake Lively withdrew the social media subpoenas at pretty much any sign of resistance. It was clearly just designed to scare people and punish them for speaking out against her. Because anytime somebody filed a motion to quash, no matter how bad the legal arguments were, and I think mine were probably pretty bad, I mean, factually it was sound, but legally, no matter how ineffective it would have been in the legal arguments, she withdrew immediately because she had no standing to do that. There was no reason for her to ask for her information. People have the right to express their negative opinions of a public figure in a high public interest case. But I have talked about that to death, so I'm not going to bore you too much with that right now. I do have some more to say on that subject a little bit later on, because in some of Justin Baldoni's interrogatory responses, which were just unsealed, he talks about how the criticism against Blake Lively was organic, and he does actually mention the content creators that were, subject to Blake's abusive subpoena power, which I want to go over in a little while later in a different video. But Andy's social media subpoena was dismissed. That's not surprising. But then the individual subpoena was something he still had to fight, and it's been dragging on until yesterday. Now, if you remember, Perez Hilton was fighting this in Nevada. The ACLU got involved on his behalf, and Blake Lively immediately withdrew. But Andy is from Florida, like me. We don't live in the same place. We live a couple hours apart, but he fought his here in Florida. And something that a lot of people don't realize is that Florida and Nevada have different laws. So each state has their own laws regarding, shield laws, reporter privileges, whatever. I'm not saying that with the elegance of anyone with an actual legal education. I'm sorry, but you know what I mean. So what Florida considers to be a journalist and what Nevada, where Perez fought his subpoena, considers to be a journalist are different. What New York considers to be a journalist is different. But Andy brought this in front of the judge here in Florida, and the judge ruled against him, denied his motion to quash, and is now saying that he's going to have to produce a whole bunch of stuff to Blake Lively. Congratulations, Blake. Your success rate is now 1 out of 107, less than 1%. I don't know if he's going to appeal. I would like to say that I think he will, but I don't speak for Andy, and I think that Andy should be able to, say that for himself, discuss his reasoning, his thoughts for himself. I know that I read somewhere that he spoke on this during his live yesterday. I wasn't able to catch it, unfortunately, and said that he would rather go to jail than give up his sources, and I think he might be pretty serious about that, so I don't think this is over yet. And frankly, if I were him, I would feel the exact same way. Some people are going to think that's crazy, but no, absolutely. I would absolutely. This is a hill that I would die on, just like the free speech issue and the abusive subpoena power to scare people. This is a hill that I would absolutely die on, and I think Andy would too. So I'll read over a little bit of the judge's ruling. I'm going to comment on some stuff just from a public opinion standpoint. There are going to be some things that I'll want to go over with Omar later. I did text him last night. I don't know when we're going to do it, but we are going to go through some of this stuff to talk about, the legal stuff that I may not understand, It happens. But before we do that, I wanted to touch on a couple of things. Now, bear in mind, your opinion and my opinion, if you're watching this, may be different. That's not an insult. But given some of the comments I've read since this ruling came out yesterday, there are some common themes that I'm seeing. So I did just want to give an opinion on a few things really quickly. Number one, the ACLU is busy. They're not going to answer everybody. It doesn't mean that he was denied. If he reached out to them, they may have just not responded. It doesn't mean they said, we're not going to take your case, right? They might just not respond to you. I believe I saw another creator, I think it was Without a Crystal Ball, I'm not sure, had said that they reached out to the ACLU at one point, and I think it was for a different case. I'm not positive, but they just like didn't answer back. And there's a lot going on in this country right now. So the ACLU, they might just not answer back sometimes. The ACLU in Nevada, who decided to take on Perez's case, is different from the ACLU here in Florida. So it's not as simple as Andy snapping his fingers and saying, I agree with everyone in the comments section, ACLU, take my case. Like, he can't just do that. And also, he was on a time frame here. He couldn't count on the ACLU answering him, much less taking his case within that time frame. So I think that I understand why he may not have depended on that and why he wanted lawyers fighting for him that he had to pay for. Second, I've seen a lot of comments about the fundraising. He did, crowdfund some of his attorney's fees. And I personally don't have an issue with that. If you want to ask for help, you can ask for help, and people can say no. There was no point in time where I saw him advertising any fundraiser saying, give me your money and I will definitely win and we will defeat Blake Lively and then we can storm the Hill. That's not what happened. There was no guarantee. His supporters chose to support him. That's what they wanted to do with their money. They had an option to do that. And if you don't want to do that, then don't. And frankly, the hate and vitriol is a little intimidating to smaller creators, especially who think about asking for help in these situations. I don't care if you have a channel that's 10 times the size of mine or even bigger than that. If you, make your hard-earned money and you pay your taxes on it, and then when it comes time to spend your money on yourself and your family, like, oh shit, this horrible, heinous monster who has all these media giants backing her is trying to sue me to waste all my money. Like, I would think that it's okay to ask for help in that situation, yes. And that's just my opinion. Like I said, if other people have different opinions, fine. We don't need to fight about it. It's not an insult to each other. That's just my opinion, and that's what I wanted to say about it. This is a place where we can disagree. I'm fine with that, but just be respectful. And that brings me to my last point here, which is I like Andy. I know Andy off of the internet. He's a person that I've actually met and gotten to know. And I value building relationships offline and having a personal connection and really understanding somebody's perspective on things. And that is how I make my character judgments, not based on what I read about them in a comment section or rumors that go around about them, or even things that you might read on a news site. I have absolutely learned my lesson when it comes to making snap judgments about people in response to bad headlines or, bad comments. In a general sense, I'm not here to force anybody to like anybody. I don't like when people publicly fight with each other. I think it's unproductive and messy. And honestly, it just makes me feel stressed out. I mean, I know some people have some not so nice things to say about me, but I don't need to see that. You know what I mean? And so Andy's developed, obviously, some thicker skin. He's had a lot more experience with this than I have. But I know that when I see a lot of criticism and it's towards someone that I like, it feels kind of bad. So I will say this. If you are, writing in the comments, like, I disagree with Andy on this, or I don't like that Andy did this way, whatever. Okay. You don't have to, censor yourself or whatever, in the sense that you can't say anything that you disagree with anything that he does, or you don't like this or that he said. It's not that, but the same with any other creator. If I see somebody slamming someone in the comments, I'm gonna nuke that, into the digital netherworld. All right. I don't really care to have comments on my YouTube channel saying, I don't like this creator, I don't like that creator, this person's a grifter, this person's a skank. No one said anyone was a skank. I mean, I'm not yet, but I'll save that one for later. But you know what I mean? If I see comments like that, they're going to be removed. I mean, I just don't. This is just not the place for that, really. I want to talk about what's going on in the court case here, not who you don't like and why. You know what I mean? I'm not telling you can't do that. I'm not telling you can't feel how you feel. You absolutely get to do that. You absolutely get to speak your mind in whatever space you have. I'm just saying, not here, please. I don't like that, especially when it's my friends or someone I'm friendly with. It doesn't help me to read comments like that and be like, okay, why are you telling me this? But there are plenty of open forums for discussion of where you can express opinions like that. And I know because I've read many, many woefully uninformed, interesting opinions about myself on some of those forums, and I no longer visit them. So, there's a time and a place. I'm just saying this isn't the place. So, all right. I'm going to stop rambling now, and we're going to get into what we're actually supposed to be talking about. Okay, so this is a Florida judge who denied the motion to quash the subpoena, basically saying that Andy doesn't qualify as a journalist. This doesn't just affect Andy, it affects his sources and the people who worked on the crew of the film, who are depending on privacy and anonymity, even, some of them, this also hurts them. So I feel like the laws here, well, whether or not they're properly applied, which, that's something I want to get into with Omar because I don't want to, speak too much on legal things that I don't understand. Whether or not the law was properly applied here, I feel that it is outdated. So that's why I'm saying I'm here to provide a public opinion standpoint. I believe the law is outdated. I feel like what we consider to be a journalist or a news source has, drastically changed since these laws were put in place. And I feel like that needs some reform. Just like I feel like the subpoena power thing needs some reform. So bear that in mind when I'm giving my thoughts here. It's not necessarily that I disagree with legal statements that the judge is making. It's just like this is basically based on my feelings. It's the court of random opinion for a reason. It's not the court of this is what the law says, That's just the court. The court of fuck you and give Blake whatever she wants, apparently, but it's just the court. Popcorn Planet moves to quash a subpoena for documents served by Blake Lively, who responds in opposition. Because Popcorn Planet fails to establish that the privilege applies or otherwise waived that privilege and fails to demonstrate an undue burden, the amended motion to quash, document 2, is denied. The matter relates to Lively versus Wayfair Studios, which is pending in the Southern District of New York. Lively sued in December 2024 and alleged that during production of the film, she experienced sexual harassment in an organized campaign of retaliation led by her co-star Justin Baldoni. According to the complaint, Baldoni engaged crisis manager Melissa Nathan to help Baldoni get ahead of the narrative and mitigate bad press generated by Lively's complaints. The strategy allegedly included third-party advocates willing to provide a potential quote or engage with reporters on behalf of Baldoni and others, and the seeding of content on traditional and social media platforms. Guys, none of that, by the way, and this is just recapping her allegations, right? None of this has been proven, but none of that, by the way, is anything you can convince me that Blake Lively's publicists aren't doing. The difference is that Blake Lively is pointing to this standard, PR behavior and calling it a smear campaign and saying smear campaign, smear campaign, smear campaign so much that standard PR practice, which the public is not necessarily too up to speed on. We don't really know what happens behind the scenes. And in a general sense, like people who follow things closely like this on the internet, yeah, they might understand. Like Ashley Brianna Eve, she understands kind of the workings of the PR stuff. So I listen to her a lot. She's a good friend. But people in general don't understand that these things happen behind the scenes. So these things that all of these celebrities are doing, Blake Lively is now putting a spotlight on it in the context of what happened with Justin Baldoni and calling it nefarious. But it's actually not any different than she or probably any other celebrity has done. I would say the only difference is that she added some stuff she made up to make it sound worse, and that isn't working out well. Sorry, it's like I always say, if only she had successfully subpoenaed my bank account number and my geolocation data from months before I ever knew about her court case, then she probably would have been able to claim, prove her claims that she was defamed. That will never not be stupid. Like, this is a story I will be telling forever. And probably something I'll write about if I do end up applying to law school. Like, I told people I was supposed to take the LSAT a month ago, but then I ended up postponing until February. But if I do end up applying, right now I'm just planning on taking the test, then I'll probably write about it at some point in a statement or something. Having to deal with a court system like that. Because if I do, go into law to be absolutely focused on First Amendment issues. But we're a long way from that kind of decision. In an amended pleading, Lively alleges this campaign continued after the filing of her complaint. According to Lively, the defendants directly engaged with media platforms to overwhelm and confuse the public's understanding of Miss Lively's allegations and to drive negative sentiment against Miss Lively and anyone who supports her or speaks out against Mr. Baldoni. Poor Miss Lively. She's just so misunderstood. She's just trying to help the poor, stupid public whose privacy she tried to violate. Even the accounts with single or double-digit followers who didn't like her or said something she didn't like based on astrology. What is wrong with you? I'm sorry, this is why I try to skim over so much of this recap stuff. It's because, like, reading it back, it just gets more and more ridiculous. Okay, I'm gonna have to do a better job of skimming here, or I'm gonna be on my soapbox all morning, and I can't do that, okay? She tried to bring in Brian Friedman, alleged that he was defaming her. She said the defendants allegedly seeded social media content with content creators on online chat sites like Reddit and publications with small audiences and lax editorial standards. The team would then amplify that content by sharing them with larger publications. Among her claims, Lively alleges defamation and defamation per se by Baldoni and others through their agents, including Brian Friedman, based on their publishing false and defamatory statements about Lively. Andy Signore is the founder and CEO of Popcorn Planet Inc., which he describes as a publicly accessible news and commentary channel with nearly 1 million subscribers and a large daily viewership hosted on Popcorn Planet's designated YouTube channel. Let's fix this. Signore claims extensive experience in journalism and entertainment news reporting. On July 1st, Lively subpoenaed him for 7 categories of information related to the underlying action. We're not going to go over all that right now. In the amended motion to quash, Popcorn Planet argues that the subpoena seeks material covered by the journalist's privilege, that Lively cannot overcome the privilege, and that the subpoena imposes an undue burden because Lively could obtain the documents from the defendants. Lively responds that the subpoena does not seek privileged material, that even if it does, she can overcome the privilege, and the subpoena imposes no undue burden. Rule 45D3A, FRCP, requires quashing or modifying subpoena on timely motion if the subpoena requires disclosure of privilege or other protected matter, if no exception or waiver applies. A person withholding subpoenaed information under a claim of privilege must 1. Expressly make the claim, and 2. Describe the nature of the withheld documents, communications, or tangible things in a manner that, without revealing information itself privileged or protected, will enable the parties to assess the claim. The party invoking a privilege bears the burden of proving it. A blanket assertion of privilege is insufficient. Rather, a party asserting privilege must establish the privilege for each document withheld. The 11th Circuit recognizes a qualified privilege for journalists, allowing them to resist compelled disclosure of their professional news gathering efforts. This privilege shields reporters in both criminal and civil proceedings. A party can overcome the privilege by demonstrating that the information is relevant and unavailable elsewhere, and that a compelling need supports disclosure. Under Florida statutes, a professional journalist has a qualified privilege not to be a witness concerning and not to disclose the information, including the identity of any source, that the professional journalist has obtained while actively gathering news. This privilege applies only to information or eyewitness observations obtained within the normal scope of employment and does not apply to physical evidence, eyewitness observations, or visual or audio recordings of crimes. So here's where, with the Florida statutes, it gets kind of tricky for Andy. The Florida statute defines a professional journalist as someone who regularly engages in collecting, photographing, recording, writing, editing, reporting, or publishing news for gain or livelihood. So we're good on that first part, right? At least I feel that he could make a case for that, obviously. But here it says, and who obtain the information while working as a salaried employee of or independent contractor for a newspaper, news journal, news agency, press association, wire service, radio or television station, network, or news magazine. So they would have to successfully argue that Popcorn Planet Inc. falls under one of those categories, and that Andy is an employee of Popcorn Planet, right? It specifically excludes from its coverage book authors and others who are not professional journalists. Although this applies to professional journalists only, the statutory language encompasses journalists working outside of traditional print media. So this is why I'm saying, like, I feel like this is sort of outdated. I think the law allows for too much exclusion of people who should be afforded the same privileges as traditional legacy journalists. So whether or not the law was applied correctly here or not, it sucks, is what I'm saying. I know that's not very professional, but my opinion is that fucking sucks, okay? So in the analysis here, it says Popcorn Planet fails to show that the journalist privilege applies and otherwise waives its claim of privilege. Signore formed Popcorn Planet for the purpose of media production. He claims that he is an investigative reporter and receives a salary from Popcorn Planet. And there was something here about a declaration claiming Popcorn Planet as a 501c3, but the publicly available records say otherwise. I don't know enough about this to comment on it. That's one of those things we're going to have to go over later with Omar or somebody else. Signore describes Popcorn Planet as a publicly accessible news and commentary channel and himself as the show's main host. Popcorn Planet's channel is an account on the website youtube.com through which Signore publishes content. Signore describes the channel's content as news videos, some of which feature legal experts to comment on high-profile court cases involving celebrities. And this is where I get a little bit pissed off. Look at footnote 3 here. Popcorn Planet is little more than a YouTube channel. Popcorn Planet maintains a website that operates as an online shop for branded merchandise. Popcorn Planet has no independent website for hosting its video content. Popcorn Planet maintains an online account through the web service Patreon for funding, as well as accounts on other social media platforms, such as Facebook, Instagram, and X, formerly known as Twitter. Popcorn Planet's social media links directly to the YouTube channel as its homepage for its content. Popcorn Planet's content, including any paid exclusive content available through its Patreon or web store, is published and hosted exclusively through YouTube. So what? That's where I'm saying the way that we're defining a journalist is so fucking dated. The way that we report and consume news content is so different than it was, like, what, even like 15 years ago? If I'm looking for the news, even if I'm looking for the news reported by a specific station, say I wanted to see what News for Jacks was saying about something, I would go to their fucking Twitter page or their Facebook page or their YouTube channel. I'm not going to newsforjacks.com because that's a mess of advertisements and stories that I don't care about. Sorry. There was a survey a couple months ago where adults under 30 said that they regularly get their news from fucking TikTok, of all places. Okay, there was over 40% of them. Okay, and in 2020, 5 years ago, that number was under 10%. Things are changing, and the law needs to change with it. You have actual established legacy media outlets using sites like Reddit to post their content, using sites like TikTok to report the news, because that's where people, especially Gen Z, are heading to look for new information. I'm not saying there's not a ton of misinformation out there. I think getting your news off of TikTok is fucking heinous. But if you make it so independent journalists are more protected, then you might start to get better information from more sources there. Of course, that could go the other way, but that's an argument for a different time. I mean, give me your opinion in the comments if you'd like. I personally will never be a person who gets my news from TikTok, okay? But from YouTube, sure. Especially when it comes to political content and the like, I'm able to find specific independent reporters with independent ideas who give a more nuanced view of things. And I see where they, cite the information they're getting. I'm able to read more about it myself. I feel like that is trustworthy and transparent, and I like that. Signore claims that he is unquestionably entitled to invoke Section 90.5015, as well as the common law federal privilege. He asserts that Florida courts have already determined that statutory journalist privilege under 90.5015 applies to internet-based entities as long as they report the news. However, none of the cases cited by Signore determines as much or contains significant analysis of the statutory language. So there's a footnote here about that. It says Signore's motion contains the wrong citation for Gubarev versus BuzzFeed Incorporated. And that, again, is something that I'm going to have to get into more with Omar. Similarly, Signore claims that he is a professional journalist, but offers no analysis of the statutory language and concludes without explanation that Popcorn Planet satisfies that language. Finally, he claims that the content published by Popcorn Planet constitutes news because that content is information of public concern, namely in the categories of entertainment, culture, and current events. To qualify as a professional journalist, Signore must regularly engage in the collection and publication of news while working as a salaried employee or independent contractor for a newspaper, news journal, news agency, press association, wire service, radio or television station, network, or news magazine. Yet he says nothing about how Popcorn Planet fits within the meaning of these terms. For example, Popcorn Planet concludes without analysis that the channel is the type of employer contemplated by the law. However, a YouTube channel such as Popcorn Planet is clearly not a newspaper or news magazine under a plain and ordinary meaning of those terms. Even if Popcorn Planet could muster a definition broad enough to cover its YouTube channel, any interpretation must consider the context in which the term appears. The law is precise and clearly intended to exclude certain types of media, as evidenced by the exclusion of book authors and others who are not professional journalists. The definition of professional journalist includes within its scope of professional news organizations, which are distinguished in part by the exercise of editorial standards and control. Nothing submitted by Popcorn Planet suggests that its show practices the editorial standards normally associated with a professional news organization. Furthermore, although Signore investigates entertainment news and creates content, his position at Popcorn Planet is not the type contemplated in the law. Signore says that he is employed by and receives a salary from Popcorn Planet, but he's also the owner, founder, and CEO, the host, director, editor, and main producer, as well as the registered agent of the company. Thus, he is self-employed, and Florida courts have historically held that the journalist privilege applies to journalists employed or hired by traditional media outlets. And that's what I think really needs to change. As explained during the first hearing on Popcorn Planet's motion, whether the privilege applies depends not only whether Signore is employed as a professional journalist, but also on whether he was engaged in news gathering at the time that he obtained the information. He is not necessarily engaged at all times in professional news gathering in the same way that a lawyer is not always engaging in attorney-client communication or working in anticipation of litigation. He cannot assert a blanket claim of privilege over his activities, but rather must assert that privilege on a document-by-document or item-by-item basis, as would any other holder of a constitutional or statutory privilege. So I believe that's why they had to do a privilege log. Furthermore, Rules 26 and 45 require a timely and express claim, as well as a disclosure of information sufficient to support his claim. And I just want to point out, as I'm skimming over these kind of footnotes here, the values and principles and the editorial standards and ethics that these news organizations are supposed to abide by, they don't necessarily always lead to ethical practices, in my opinion. Just look at what the New York Times did with Blake Lively. Lively served the subpoena on July 3rd. Popcorn Planet moved to quash on July 25th, 2 days after the time required for compliance. As of October 22nd, Popcorn Planet had not produced a privilege log identifying responsive but privileged documents and had not sought an extension. After requiring the parties to confer about the scope of the search for responsive documents, an October 31st order required Popcorn Planet to produce a privilege log no later than November 5th. Popcorn Planet moved for an extension of time and attached a preliminary privilege log to its motion. During a November 7th status conference, I explained to Popcorn Planet that the privilege log was inadequate. For example, in one entry, the log identifies a text string spanning from January 1st to June 24th, 2025. The description, that entry, along with every other entry, is a vague conclusory statement essentially saying the item is privileged, which provides little basis from which to evaluate the claim of privilege. So I don't know too much about how detailed a privilege log needs to be, or like how it's separated out, that kind of thing. So that's another question for Omar. I will say I don't know about the dates here and like the late submission, like the 2 days after time required for compliance. I don't know. These are things that I can't answer. So in response, counsel for Popcorn Planet argued that it was nonsense or absurd to suggest that he had to log or itemize each and every text message subject to the privilege. So that, again, I don't understand. Like, I need to look at that document and see exactly what they were saying there. I don't want to draw any conclusions based on that. I'm a little confused by that, but I digress. Consistent with counsel's position that the law does not require particularity and that Popcorn Planet can claim the privilege categorically, the final privilege log filed by Popcorn Planet contains no changes except for the addition of 2 items. Counsel for Popcorn Planet is incorrect on the law, and he fails to show that the subpoenaed communications were privileged. He produced no privilege log until ordered to do so 3 months after receiving service of the subpoena. Thus, Popcorn Planet failed to timely provide a privilege log, and despite repeated opportunities to correct this omission, Popcorn Planet failed to produce a privilege log with sufficient particularity to assess the privilege claim. This results in a waiver of the privilege. So this right here is something I feel like, is that like a pretty big misstep? Like, that's what I don't understand. And the thing is, like, I don't want to like ask Andy, this is like an ongoing, case, and be like, hey, what the heck? So like, if he wants to explain that to people, he can. That's his thing to do. All I can do is speculate based on what I'm reading, and there's a lot that I don't understand about the privilege log stuff. Like when he was required to do that, and why he would have been required to do that right away. I never seen anything like this before. So I'll be honest. There's going to be a lot I don't understand, so I want to wait until I have someone who would know a little more about this stuff to talk with me about it, which should be soon. Not tonight, though, because we have the responses to the summary judgment and all that. So I'm going to be buried for the rest of the week. Okay. So basically, the judge is saying he waived privilege there. An in-camera review of documents included in the privilege log demonstrates the problem with Popcorn Planet's generic and conclusory privilege log. For example, item 4 on the privilege log is a 6-month-long, 89-page text message conversation between Signore and a defendant in the underlying lawsuit. So when they say a defendant, I don't know who that is. I know that he did reach out to both sides, all sides, I guess. Stephanie Jones is like her own separate thing. I know he reached out to everybody regarding the documentary. I don't know if that's what this was about. We have no idea what these texts were about. The judge reviewed them, in his quarters, and we're not privy to see that. I do know that he's been covering other celebrity cases and stuff for a long time. It's possible he was talking to one of the publicists about other things entirely. I have no fucking idea. You're going to hear a lot of people more on the lively side who are going to say like, oh my God, this proves everything. He was, and that's just, they're saying, basically asserting what they want it to be. They're going to tell you what they would like you to hear, what they would like to be true. And if I were to say to you right now, I know for sure, like, Andy was not talking to any of them about Blake ever, and like nothing was ever said, then I would just kind of be telling you what I want you to hear and what I want to believe. And the truth is, I don't fucking know. So I can't tell you what the deal is there. I don't know. So there's not much more I can really say on that for now. If Andy wants to talk about that, he can. I'm not going to ask him about it. I don't feel like it's my place, but that's his deal, and I'm not going to speculate too much on it. It doesn't mean anyone did anything wrong, by the way. People are allowed to talk to publicists. It's a standard thing. Like I said earlier, like these are standard things that publicists do for all celebrities. As one would expect, the conversation contains some information that is clearly irrelevant, unresponsive, and not privileged. So there you go. That's important. So there's 89 pages, he points out, but some of the information is clearly irrelevant, unresponsive, and not privileged. So it has nothing to do with Blake or her case. So that, lends further kind of support in my mind to the idea that they were talking to the publicist about something else entirely. The text message conversation constitutes the bulk of the material in the initial privilege log, which contains a mere 142 pages. Yet the log nowhere specifies the number of individual messages, pages, or specific exchanges to which the privilege allegedly applies. That sounds so fucking tedious. I would not want to be the one putting that together. Actually, maybe I would. Does that mean I could read everything? Maybe I would. I want that job. The final privilege log contains only 2 additional items, which suggests that the final universe of documents is not much longer than 142 pages. Thus, Popcorn Planet cannot plausibly claim an undue burden in having to separate these documents into their relevant and purportedly privileged parts. Even if the inadequate privilege log caused no waiver, Popcorn Planet's production of documents has. A comparison of documents included in the in-camera inspection with those produced to Lively reveals no discernible substantive difference. Items 5 through 17 and 19 are inquiries by individuals associated with Popcorn Planet seeking comment from people involved in the film who provided no substantive response. So he reached out to some people who didn't respond. That's not surprising. He reached out to everybody, like I said. They either didn't respond or they gave no substantive response. These emails are similar in content and character to the emails produced by Popcorn Planet to Lively, yet Popcorn Planet provides no information about why some inquiries are privileged and other similar inquiries are not. Accordingly, I find that Popcorn Planet fails to establish that the items responsive to the subpoena are protected from disclosure under the journalist privilege. And then B says, even if Popcorn Planet established that the privilege applies, Lively overcomes it. The requests that Lively sent in the subpoena are directly relevant and material to her claim that the defendants in the underlying action orchestrated a campaign to defame her with the help of third parties who created disparaging and false content. Furthermore, an in-camera review reveals that the responsive materials are directly relevant and material to Lively's claim. Lively further establishes that she tried to discover this information from the defendants and, to some extent, has been unable to obtain these materials from them. Lively demonstrates a compelling need because the materials go to the heart of the matter, that is, the primary theory underlying Lively's defamation claim. So this is information that could possibly be used in an argument. It doesn't necessarily prove anything. It doesn't mean anyone did anything wrong. However, there were communications, I guess, that are talking about Blake Lively and her case, which is not that surprising given he was working on a documentary about her case and whether or not she was defamed. So I'm not really surprised by that. I find it extremely annoying and I disagree with this. I feel like talking to people about whether or not Blake Lively was defamed really shouldn't be a reason to pierce privilege, but like the judge said, he was, denying him the journalist privilege anyways. But, we can't see what was in the in-camera review, so there's only so much that anyone can really tell you about this and why the judge said what he said here. So don't get too caught up in, people speculating about that. The truth is, like I said earlier, we don't fucking know. And any content creator, like random Twitter user, whatever, who tells you otherwise is not being entirely truthful, and they're basically telling you what they would like you to hear. So Popcorn Planet argues a subpoena imposes undue burden because it seeks extensive document production and because Lively has not exhausted more direct avenues. And here's another thing I don't understand. During the first hearing on Popcorn Planet's motion to quash, counsel admitted having not discussed the scope of the request or the attendant search with counsel for Lively. And I'm a little confused by that. I'm not understanding why they went that route. So you guys will have to give me your thoughts on that. I feel like that's something they usually do during the process of this, but like I said, I've never really seen too much like this before. So when given an opportunity to raise objections to the scope of the request in the subpoena, counsel for Popcorn Planet said, "I don't have a problem with the scope," and affirmed that his only concern was with privilege. And I don't really totally understand that route, but I know Andy has his lawyers on sometimes. Maybe they can speak to that, or I'll have to go back and watch some of the stuff that I missed and see if they said anything about it. That's something I don't necessarily understand why they went about it that way. But like I said, I just don't understand. So, and the judge says here, nothing in Rule 45 requires a party, that would be Blake, to exhaust all other sources of information before pursuing third-party discovery. And we've talked about that regarding subpoenas in the Lively case, in the Jones case. So accordingly, the amended motion to quash is denied. Popcorn Planet must produce all responsive material to Lively, including every item in the privilege log, as well as the attachments to those items. To the extent necessary and not already covered by an order in the underlying action, the parties may propose a stipulated protective order governing the handling of this information. All right, I got to get going to work, so there's not much more I can talk about right now, but let me know your thoughts in the comments, and I'll be back later today for sure. Remember, we have the responses to the motion for summary judgment, motion for judgment on the pleadings, and all that due. I'll probably do one tonight, one tomorrow, and then some other stuff has come up that I got to catch up on that I missed last week. So I'm going to have a busy day, not even including my day job, which I have to go do now. So thank you everyone for watching, and I will see you all soon. Bye.